Hello everyone, I'm Mustafa, an associate professor at Ufa University of Science and Technology, Institute of Law, and also legal counsel. Welcome to Mustafa Contract Law Hub, your go-to resource for mastering contract law, from fundamentals to advanced concepts. Whether you are a student eager to learn, or a professional sharpening your skills, or simply someone interested in understanding how contracts work, you are at the right place. So let's embark on this journey and explore fascinating field of contract law together. Today, I'm going to talk about this important information or these important concepts under the contract law, acceptance. In fact, I told you about an agreement and 5 requirements that we have under the contract. So here, one side of the agreement is acceptance. What is acceptance? When I'm a person who makes offer as an offer, so on the other hand, I need acceptance. Maybe it's for individuals, maybe for public, and here, maybe acceptance by some words or no, just by some conducts. So it's based on situation. I tell you more and more about it today. And acceptance is the words of the offeree. In return, offeree makes acceptance based on the situation. Okay, this acceptance as well is critical one because we need to analyze the time, we need to analyze the exceptions and so on that I tell you today. Key features of acceptance. In fact, when we have acceptance, we need to analyze the validity of this acceptance. First one, unconditional agreement. As you see here, the acceptance must be based on the terms of the offer. Otherwise, we have counteroffer. I told you in previous videos about the counteroffer and all the aspects of offer. If you have acceptance, it must be in accordance with offer. Otherwise, it's counteroffer. And communication. The acceptance must be communicated to offer because I'm, for example, an offer and I need to know about the acceptance. By the way, maybe there are some circumstances and exceptions. I tell you about these exceptions as well. And timing is another point here because if right now the offer made offer, so we need to know how much time we have to make an acceptance. Sometimes the offer is based on a specified time, but on the other hand, maybe we don't have a specified time, but we have reasonable time. So we should analyze case by case because subject matters is important here or some circumstances, the quality of the subject matter like perishable goods and so on that I told you on the subject of offer in previous videos. Acceptance under the unilateral contract. Just one point here because the unilateral contract, as I told you, is contract that only one party tries to make promise and in return there is nothing. In return, there is no promise. So it's a unilateral contract. Based on this type of contract, we have acceptance in the way of conduct. In fact, the offeree or the person who doing a role like as an offeree must conduct some special manners, some special actions that the offer mentioned under the term of offer. So here, acceptance based on conduct. The other one is negotiation and battle of the forms. as you see here, is another important concept, because here about the long process of negotiations. If we have long process of negotiations, so there are some difficulties. Why? Because maybe the parties here, they don't know when they have offer and what in which point or under what conditions they have offer or acceptance. So this offer and acceptance must be analyzed based on circumstances, and the course try to look at every points of these negotiations, because it's long-term negotiation and need to be analyzed. But the battle of the forms. So under these negotiations, maybe the parties need to do some kind of exchange regarding the forms, standard forms related to contract. And here we see some special situations, because we need to see what kind of rules, for example, we have, or what kind of conduct must be analyzed. For example, in modern commercial law, particularly under the Uniform Commercial Code, we see the last shot approach or conduct, and it's based on the conduct, it's based on the enforceability. But on the other hand, if we see mirror image rule, is based on traditional communication, and exactly acceptance must be based on the terms of the offer, not in other way. Maybe it can be considered as counter offer. So it's case by case in long-term negotiations and in a battle of the forms. And also specified methods of acceptance. Sometimes you see some terms under the offer that is made by offerer, and under these terms you see some special manners. For example, the offerer mentioned only I want to see acceptance by email or in writing or in other ways based on the terms. So if the offeree doesn't do based on these terms and doesn't make the acceptance based on these terms, so it's not valid acceptance. And exceptions, I told you about the communication, that is so important, but there are some exceptions here. I found 6 exceptions about the communication. In general, the acceptance must be communicated to offerer, but in some exceptions, maybe there is no need to communication, and again, case by case must be analyzed. What are these exceptions? Acceptance under the unilateral contract that I told you is based on the conduct, and maybe sometimes based on terms acceptance under the bilateral contract, and acceptance by mailbox, or acceptance by silence manner, or acceptance in the way that offer mentioned it. I don't need, as an offer, I don't need to communicate. And also maybe under the customs, some special customs. So here you can see these exceptions. First of all, acceptance by conduct or unilateral contract. I told you only one person here made promise, and there is no exchange here, there is no promise in return. So here, if the person did some special actions based on the proposed offer, so we have valid contract at the time. There is no need to communication. There is no need to the acceptance be communicated here. And only conduct. And also acceptance under the, as you see here, mailbox and we can call it mailbox rule is traditional one. And if we have acceptance by mailbox rule or under the mailbox rule or by mail, the time is so important because the time of posting or dispatching is so important. This time is time of acceptance, not the time of receiving, not the time of receiving of this acceptance to offer. The time I'm as an offeree posted or dispatched this acceptance or this letter is important. And how about new version? Maybe you have this question. How about the new version of communication, like electronic communications or emails? It's based on the jurisdiction. In fact, if you have acceptance by email, here majority of the course apply this rule, the traditional rule related to mailbox for these new versions like email or Telegram or WhatsApp or so on. But it's based on the jurisdiction or legal system, as I told you, because it's not a rule like the mailbox rule. So case by case must be analyzed again. And acceptance by silence. In general, silence is not considered as an acceptance, but maybe we have a prior course of dealing. So based on this course of dealing, maybe silence can be considered as an acceptance. Or no, on the other hand, the offerer mentioned that I consider this silence as an acceptance. It's case by case again. It must be analyzed. And acceptance by performance, as I told you about the unilateral contract, but here is bilateral one. So what's happening here in bilateral one, we have some kind of exchange. I pay you something or I give you something, you pay me in return. We have consideration, but here acceptance by performance under the bilateral contracts means I want you as an offer, I want you do special action or act, and this special act or action is considered as an acceptance. And also when the offer mentions such a thing, the offer, the person who made the offer, so made or proposed some special terms. Based on these terms, the offer mentioned, okay, I don't need to communication, and it's enough for me to do, for example, some special work, some special action. So it's based on the terms as well that offer mentioned. Established customs is another one because maybe you see some special customs. In that way, you see there is no need to communication. There is no need that acceptance be communicated. And the last question for this video and this time is about the time of contract. When the contract considered to be formed. In fact, the time of acceptance is so important. When the offeree made an acceptance, I told you, it's again based on situation. Maybe you see conduct is considered as an acceptance, or no, we need acceptance be communicated. So the main point is related to time of acceptance. When we have valid acceptance based on the circumstances that I told you, we have valid contract. And the last slide. Thank you so much for listening to me today, as always, and joining me. I wish you the best, and I have so beautiful information for you. See you soon. Bye.